Good morning and welcome. It is Sunday, March 22nd, 2026, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. What is going on, Ritter? It's 3 minutes in. You're 3 minutes late. I apologize for that. It's a Sunday. Our kids refused to get going this morning. I will supply you with no other excuses, but only apologies. I'll give you an extra 3 minutes at the end of the show. But thank you all so much for being here. Little Miss Red Velvet and Afton and Lindsay Bay and Shy Gal and Full Throated Motion and Proud Grizzly. So good to see so many familiar names and faces. So good to see so many new names and faces. Welcome. Welcome, everybody who's new here. I would love it if this was your first show because it's going to be a really fun one. This is a show that we do every Sunday, but let me introduce myself first to everybody who is new. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for over 10 years before I left to go into private practice as a criminal defense attorney. And this is Courtroom Confidential. Pardon me. We started this channel with the mission statement of presenting to you both sides of the courtroom, both sides of the issues, both sides of the stories, and we hope that we do that. And then we started this show, Sunday Fun Day, that takes place every Sunday. It's in the name, just to not confuse you, where we take your questions that you've left us throughout the week in voice messages, and we're going to now answer them live right here on this show. So you're in for a treat because we have a lot of really great questions today. And too many great questions. In fact, I'm going to upfront apologize. There were some questions I just couldn't get to all of them. Otherwise, we would be here till next Sunday. So if I missed you this week, don't be offended. Don't be hurt. Just ask a question again for next week, and I will try my best to spread as much love as I possibly can. Stay to the end for announcements. We do have some time changes coming up that I don't want you guys to miss. Some interesting, fun things in the works that I don't want you guys to miss. But in the meantime, take a deep breath, a deep cleansing breath. It is Sunday. You've made it. It's the end of the week, the beginning of the next, depending on how you like to look at it. Everything's going to work out. Hit that like button if you haven't already. Subscribe if you haven't already. Share this with anyone that you think might enjoy it. And oh boy, to kick us off this morning, this is absolutely, this sent Tiffany for a loop when we saw this morning. Debbie Haro, you are such an amazing person, and we can't thank you enough for your support. She says, I'll miss you all today. I love this. She's not even going to be here. Please, everybody, give a big shout out to Debbie when she watches this on replay so she can see all the love. Says, Sunday is family day sometimes for me, but I have you in my spirit. I'll miss Josh to wrangle out names. I miss his so sweet ending for Tiffany. If people are on that haven't joined, please do. It's fun, but so much knowledge and joy. Debbie, you're an absolute treasure, and we appreciate you. And thank you so much for the incredible generosity and for kicking us off this morning. On that note, Bez Nancy, thank you for gifting the Courtroom Confidential memberships. And, oh, I know her. Tiff Ritter has been a member for 19 months. She says, happy birthday to our amazing therapist you know. Happy birthday, therapist you know. Sending you a lot of love. What a great, I feel like we could end the show right now and it still would have been a fabulous show, but we'll do it anyways because we've got some really great questions. So let's get to it. Who's going to kick us off this morning? Where does our first flight land? Let's find out.
Hi, Josh. This is Susan. I'm calling from Virginia by way of New York. I wanted to call and ask about what you thought of the Nancy Guthrie case. If you think the case has gone cold, do you think something's happening behind the scenes? Do you think possibly some corruption in the department? I do keep up with the case from JLR's podcast. I know that they released the home back to the family, and just recently the car was returned back to Tommaso and Annie. I also wanted to let you know that I appreciate you coming on to Fox and giving your opinions and details of what's going on. I absolutely love that you teamed up with Paul Morrow, who is another one of my favorites. I do have some of your merchandise. I enjoy the t-shirts. They're very comfortable. And I love that you end every podcast with, Tiffany, you're the greatest thing that's ever happened to me. I hope you have a great day. And thank you so much. Bye-bye.
Susan, kicking us off with such a great call. Susan, you have now just won yourself the prize of being the president of our PR department. I love that. Look, just spreading the love on everything. First of all, let's put you on the map. Virginia kicking us off this morning. A couple of things that Susan brought up that I wanted to mention. One, yes, I do a show on Fox Nation. If you guys haven't heard about it, it's with a good friend and colleague, Paul Morrow, along with a good friend and colleague, Donna Rotuno. It's called the Weekly Rap Sheet. We do it every Friday if we can. We try to make it as regular as possible, but it's live on Fox Nation if you're a subscriber over there. And I think they're running a special right now where it's like $4 a month, like, or something like that for the for the first few months or something. Not sure. But please check it out. And thank you so much, Susan, for the kind words about that. And I'm so glad that you enjoy the shirts. If any of you would like to grab one of those shirts, all of them are available over at the shop at the courtroomconfidential.com. All right. Enough of shameless plugging. Let's get to your question about Nancy Guthrie. First of all, some interesting news on that is that the family gave another statement. I think it was yesterday, was it? Or today? Actually, this morning. So timely enough. I have not read this, so we're going to be reading this statement all together. This is a statement from the Guthrie family that they released on Instagram. It says, "We are deeply grateful for the outpouring from neighbors, friends, and the people of Tucson. We are all family now. We continue to believe it is Tucsonans and this greater Southern Arizona community that hold the key to finding resolution in this case. Someone knows something. It's possible a member of this community has information that they do not even realize is significant. We hope people search their memories, especially around the key timelines of January 31st and the early morning hours of February 1st, as well as the late evening, listen to this, the late evening of January 11th. Very interesting. We desperately ask this community to renewed attention to our mom's case. Please consult camera footage, journal notes, text messages, observations, or conversations that in retrospect may hold significance. No detail is too small. It may be the key." Wow. We miss our mom with every breath, and we cannot be in peace until she is home. We cannot grieve. We can only ache and wonder. Our focus is solely on finding her and bringing her home. We want to celebrate her beautiful and courageous life, but we cannot do that until she is brought to a final place of rest. Thank you for continuing to pray without ceasing. The Guthrie family, Cameron and Christine, Annie and Tommaso, Savannah and Michael. Is that it? Okay. Wow. I will say this. God, what can we take away from that? Very interesting. Well, my first thought is that, they've received 40,000 at last count, which was several weeks ago, tips. Doesn't sound like they've received that one tip that they're hoping for. Doesn't sound like, and I imagine they're still going through that. It takes a lot of time to cull some of that information. Some of that can be dismissed outright. The aliens took her. You're not going to spend a lot of time on. But something where it's like, hey, there's a mechanic that works at this station and he blah, 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 blah. That's going to take some work. That's going to take some man hours. And maybe they've worked through the majority of that and they haven't found anything that they're looking for. So they're asking continued help from the community. The other thing that stands out is this absolute solidarity of the family. And I love that they signed it off from everyone, putting hopefully to rest any conspiracies and suspicions about anybody in the family being involved. I think we can all agree that it's time to stop it with that. The family has no suspicions of anyone. They are united. Law enforcement has said so. And law enforcement has had plenty of time, in case you're all still curious about it, to have investigated everyone thoroughly. It's not somebody in the family. It's somebody outside of the family. And they believe that somebody out there knows something. And the part that stood out to me is obviously they're saying, hey, if you know something about the night before or the early morning hours of when she disappeared, great. But then go ahead and make that large again, Kaylin, if you can, as well as the late evening of January 11th. And I cannot remember if that's the first time where they have flat out identified a date. We've had other dates that have been, we know that they're curious about. I think that they made a request. Initially, law enforcement was making requests for videotape, and it included days in advance. We all thought, why do they want all this information from days in advance? Where my mind immediately went is, you remember now that they're telling us that on that video, remember there's one picture where to me it looks like the same individual, but we don't know. But he's wearing at least similar clothing, but not wearing the backpack. And not wearing the gun holster. And we thought, why in the world did he take it off? Well, now we're finding out that may have been from a different evening. Maybe that's the January 11th that they're talking about. Maybe this person had gone out there. What is that? 2 weeks, 3 weeks in advance, 20 days. That's bizarre. Had gone out there 20 days ahead of time. Yeah, there we go. Excellent, Kaylin. Kaylin's so good. So there on the left is the video, or at least a still from that video. The person in the video is wearing that, the backpack, that clothing, and the gun. On the right, we just have that still. There's never been a video attached to that image on the right. And there, he's not wearing the backpack and not wearing the gun. But it looks to me to be the similar gloves, pants, shoes, hat, who knows? I mean, mask. Again, it's hard to tell with a lot of this because this is night vision, remember. These are not true colors. But is that from January 11th? These are my guesses, if I'm not making that clear enough. These are my guesses that maybe they believe that's January 11th. Maybe that's when he went to go case out the joint. It's interesting because he's right there on the threshold of the entryway, that little kind of patio area that's still outside before you get to the front door. And maybe he never noticed that there was that doorbell camera there. And that's why he appears to be so kind of caught off guard and shocked. He came out before, kind of planned things out, realized there's no real alarm system, there's no dog, there's no real reason that might prevent him from getting inside of that home. But then when he does come back with backpack and gun in hand, he's surprised by that camera. Again, it makes you start to wonder, what was the plans of this person? Why in the world did they put so much time, energy, and planning into this crime, whatever that intended crime was? Was it an assault? Was it a kidnapping? Was it a burglary gone wrong? I don't know. I think there's arguments in favor of and against each one of those, but yeah, pretty fascinating to me. I think we calculated it the other night and we're at day 50 or close to it since her disappearance. I am astounded by that. And so to your question, Susan, is it cold? Well, I don't know if there's an official definition of that, but it does seem like they are running out of leads that are hot leads. So I will echo the family's sentiments. If there's anybody watching in the Tucson area, rack your brain for those 2 dates. And if there's anything of any kind of consequence, please call that number. All right. Well, thank you so much, Suzanne, for kicking us off this morning. And thank you to Grandma Law Nerd for gifting the membership. So kind of you. And Potter, thank you for supporting the mods with coffees on a Friday. Sorry that we missed it. Oh, yeah. We're not going to miss that. We're going back. We'll go back to thank you. So thank you, Ann Potter. And Jude the Tiger. Thank you so much, Jude, for the kind, generous gift of memberships. Always appreciate those gifted memberships. All right. Let's keep it rolling here. Where are we going to next?
Hi, Josh. This is Dee calling from Saskatoon, Saskatchewan, Canada. Longtime listener, first-time caller. I have a question about the Kouri Richins trial. When I was looking on YouTube for recaps last week of one of the trial days, I came across a video of a television interview done by KUTV2 News in Salt Lake City from 5 months ago. Her defense attorneys, Nestor, Lewis, and Ramos, came forward saying that the prosecution's false narratives would make it very hard to find an objective jury, and they wanted to set the record straight by correcting 4 main points, which they discussed in the newscast. I know they were pushing very hard to have a change of venue for the trial. So was this a way to ensure a wider audience saw this on the news and that there would be difficulty in finding enough jurors who hadn't heard about the case? Maybe I'm off base here or on the wrong track, but I'm curious as to what your thoughts are on this. Was this a good idea for them to do this? I don't think it's typical for defense attorneys to speak out before a trial, is it? The TV station said that they did reach out to the prosecutors who declined to be interviewed, but who did provide an official response, saying that they would address matters related to this through the legal process and not in the media. Anyway, I know we're at the end of the trial now, but just wondering what your thoughts are about this situation. Thanks for all you and the CCC crew do to keep us informed. I really enjoy your shows. Take care.
D, first-time caller. I love the first-time callers. I love hearing about people who've been listening and watching and enjoying and said, you know what? I'm going to work up the courage to pick up the phone or computer or however you do it and leave a message. And I appreciate you for doing that and being a part of the fun, and probably sat there and thought, nobody asked this question. This is a good one. And I want to hear Ritter tell me the answer. So thank you, Dee. And I'm especially appreciative because it gives me the opportunity to say Saskatoon, Saskatchewan, Canada, which is a mouthful. So interesting question about Kouri Richins. And basically your question, if I understand it correctly, is was the defense, they were making a big argument, really pushing for a change of venue in this case. Remember, they even appealed it. They were so intent on getting her out of that county where they felt like she couldn't get a fair shake that they even went as far as going to the appellate court. And the judge denied all of that. Now, are they looking back at that and going, hey, that is our main reason for appeal? I was actually talking with Paul Morrow, who we talked about earlier. He thinks that's their main argument on appeal is going to be, we were denied a change of venue. We didn't get a fair shake in this county. Too many people knew about it. I think that that's an uphill argument because it's really, you're doing a lot of trying to read people's minds when you make that sort of an argument. And they could point back to jury selection and go, but everyone who sat on this jury said that they weren't bothered, biased, and could be a fair juror. I also think some of the comments from the jurors coming out have reiterated that. They didn't sound like they had made up their minds ahead of time. In fact, some of them sounded almost like they were rooting for her and were disappointed that she actually committed murder. Anyhow, your question though is, were they, by doing these interviews, this kind of media campaign ahead of time, trying to push a change of venue? It is bizarre for them to all sit down like that for a media interview. You don't see that all that often. There was no gag order in this case that prevented them from doing that. I think it's a little bit inappropriate, but it's not illegal. It's not unethical. I am much more of the mindset of let your feet do your talking. Do your talking in court. If you got something to say, do it in court. But they felt that this was important. They felt that they wanted to change the narrative. Now, I'm not all that surprised that this is coming from a team headed up by Kathy Nestor. Kathy Nestor, as you know, very good attorney, and I'm not trying to disparage her by saying this, but she to me seems like an attorney who is very conscientious of the public perception in her cases, to the point of, I would call it preoccupation. And I would say that to her face if I knew her. So I'm not trying to, talk bad about somebody while they don't have an opportunity to defend themselves. I think there's a preoccupation with public perception that she has about her cases. She demonstrated that in the Kouri Richins case by asking for this change of venue by not by asking for it, but being really kind of obsessed with it. And she's doing that in the Tyler Robinson case. She also represents Tyler Robinson for the assassination of Charlie Kirk. And as you know, in that case, we have had several hearings, been to court many, many times, called witnesses, all this time spent, energy, sweat, and tears, and not talked about one piece of evidence in that case yet. It's all been about the cameras and if they can be allowed in there, and what is he wearing when he's in court, and where can the cameras be pointed, and can they be looking at their client when he's talking to his attorneys, and all of this. It's like she is the assistant director to this television series rather than the attorney. It's a preoccupation, in my honest opinion, with media perception. Now, maybe you're saying, well, she's very savvy to the current world that we live in where the media plays a role. Sure, if you want to be savvy, but at the same time, get down to the business of defending your client and maybe don't concern yourself too much with all the noise. My very humble opinion. So thank you, Dee, for being a first-time caller. Thank you for calling in with that excellent question, and appreciate you. Eroy, oh my. You guys are fantastic this morning. Eroy, again, with the tremendous outpouring of support and generosity. Thank you so much. 50 Courtroom Confidential memberships. Now everybody here should be a member at this point. So welcome aboard, all the new people. Eroy, thank you again. I'll talk more about the membership program and how much work we put into that towards the end of the show. Heather Coopersmith, thank you, as always, for the super sticker. And Gina Gilmore, thank you for gifting the Courtroom Confidential membership. By the end of this show, I think everybody who's chatting here today might just end up being a member. So thank you guys so much. All right. Let's keep it rolling. Where are we on to next here?
Hello, Heather from Lancaster, aka the top uttermost corner of LA County. Just wondering, how do we acquire Josh as our defense attorney? Thank you.
Heather from Lancaster. Yeah, right. My neighbor to the north up there. Thank you so much for calling in. I don't know if this is a joke or not, but yeah, I still work as a defense attorney. Heather, I'm glad that if you do really need a lawyer, that you're not telling me why over the chat, over the message. If we need to have a private conversation, you let me know. But actually, if you guys are looking for a lawyer or even a referral or a recommendation, go to my other website, joshuaritter.com. And there is, if you click on the contact, there's a need a lawyer box where you can click on it and fill out a little form and somebody will be in contact with you. So appreciate you, Heather, for that. How does he do it? How does he still do the YouTubes and the lawyering? I don't know. And he's got kids and a wife. He tries real hard, everybody. Hopefully he does all of those things with a C+ average. So thank you, Heather from Lancaster. Not a lot of LA County folks calling in. I've noticed that on the map. We're a little scarce in my own backyard, but Heather, thank you for representing. I think one of those might even just be me faking a phone call at one point. I don't know. I'm joking. All right, Heather, thank you again for the phone call. Let's keep it rolling here. Who's next?
Hello, Josh. This is Danielle from Central North Carolina. First, I have to say that your coverage on Fox News for the Nancy Guthrie missing case has been really great. You're so articulate and smart, and appreciate you and your efforts, commitment towards that case so much. My question is, could you speak on Melody Buzzard? I know that there is something coming up soon, maybe this week. Could you talk about that and give us an update, elaborate on what's going to be happening at this next event for her? Thank you so very much. Have a great day.
Danielle from North Carolina. Let's put you on the map. Thank you so much for the kind words. You guys are making me blush this morning. You're also nice and complimentary. I appreciate that. Yeah, Melody Buzzard. What is the latest? She was in court this week. This is obviously probably. God, we talk about some really awful stuff sometimes. When you're talking about true crime, it's just it's baked into the cake, right? You're going to be talking about some really awful stuff. But the case of 9-year-old Melody and her mother, Ashlee, who we see here, is probably the most disturbing that I can think of. As far as, you could say, well, serial killers and awful stuff. Yeah, but you've got a mother here taking the life of her own 9-year-old daughter. And that little girl, in the 9 years that she was alive, she had no one else in the world but mom. And mom is obviously unwell and obviously got some demons. And I can't imagine how that little girl managed to have a smile on her face at one point in her life. And then her life ended with her mother marching her out to the middle of nowhere and putting a bullet in the back of her head as if it was some sort of mafia hit. It just breaks my heart the more I think about it. She was in court on Wednesday, actually. Now, this is the first time that this coward decided to go ahead and make an appearance, because until now, she has been saying that she's too sick to come to court. Well, the judge said nonsense to that. If you don't show up at the next court date, I'm going to get an extraction order, which is essentially saying I'm going to drag your sorry butt out of jail and put you in court because we need to talk. They have a motion, the defense does, challenging the search warrants in this case. No surprise there. Nothing really going to come of it. I think there are plenty of avenues where they would have found all of this evidence anyways. There's a lot of arguments to be made about inevitable discovery and, even if there were insufficiencies or problems with the warrants, but it doesn't sound like there are any problems with the warrants. But this is what you're going to see for the next several court appearances, is them kind of filing motions here and there, challenging things along the way where they can. Buzzard did agree to waive her right to a speedy trial through May. So her next court date is going to be in April. In California, the way that they do it is that you actually have continuing kind of deadlines. You don't just forever waive your rights. You waive your right until, 60 days out from the next court date. So that's kind of what you're going to see, is her continuing to waive time. We call it continue this. This thing's going to drag on, my fear is, for a very long time. And I don't think we're going to see many surprises out of it. I think we're just going to hear about the horrific last few days of Melody's life. And it's probably going to end up in a trial. I don't know if she'll take a plea. She's looking at life without parole. They've already announced that they're not going to seek the death penalty, which was a little shocking to me. Could have to do with perhaps the mounting mental health defense, though I don't think that's going to go anywhere given the amount of planning that went into this. It's one of those cases where you care about it an awful lot because of what happened. But as far as the interests in the legal twists and turns, I don't know if there's going to be many. I think it's going to be a fairly straightforward and depressing case all along the way. But thank you again, Danielle, for the kind words and for calling in and for putting North Carolina on the map. So appreciate you. All right. Kathleen Roloff, thank you so much for gifting the membership. Big old smile on Kathleen's face there. To Jude the Tiger, thank you for supporting the mods with coffees, keeping those mods awake this morning. And to Derek Sherman, one of my dudes, says, "Morning, Josh. Brian Enton recently mentioned that January 11th and 24th dates were the dates that the reorganized investigators were asking all the neighbors for any home videos. Have a great day." Yeah, that's what I was referencing. There was a point where they had referenced other dates and never really explained why. So January 11th obviously is a date of importance, even to the point that the family is speaking about it. my best guess is that January 11th must be, remember they pieced together this footage from the Nest camera that was lost in kind of the digital cloud. And they were able to resurrect that footage from the grave, piece it back together, and give us some video. And it's fragments, right? It's whisperings of things that were digitally found on that device and in the cloud of Google. And so it could be that they were able to now determine when some other footage showing the suspect what date it was on. This date, the date of the actual break-in, fairly obvious. But maybe now they know that January 11th was a date that suspect may have been at that place before. January 24th may have been another date as well, which just makes this more and more chilling to know the tremendous amount of planning that went into this. This isn't some crime of opportunity, some guy out just looking for, a house to break into. It sounds like this house had been targeted, thought about, planned about for at least several weeks in advance, which is even more mysterious and even more disturbing. So thank you for that, Derek, and thank you, Chantel, for the call. All right. Where are we off to next here? Already tremendous, great calls this morning. Let me make sure I'm not losing my place. All right, here we go.
Hey, Josh, CC Crew, Tiff, Kaylin, it's Chantel from Newcastle, Australia. Got 2 questions, so I'll need to make these one quick. First one, Josh, when you introduce yourself on episodes, you say award-winning attorney. Please, Josh, tell me more about that. What awards have you actually won? And I'm serious, I hear that, I'm like, wow, that's cool. What have you actually won? Love to know. Second one, really invested in the Kouri Richins trial. Been watching it every day, but sorry, I've been watching it over at Grizzly. Got to be honest. Only because it's the snark. I can't not watch it, hey? Anyway, when something is said by the state or defense and there's objection and overruled, okay, so it means that they can keep going on with their questioning, or it's accepted on the record. As a jury, when it's like, okay, I've heard that, well, hang on a minute, now I can't hear that, or I can't use that in making my decision if it's something quite significant and important. As humans, I know that I probably couldn't forget what I've just heard, and I know that you're meant to just forget what you've just heard, especially when it's moved to strike, get it off the record, out, not having it. How do you know they haven't used that? How do you know they haven't used what you're not allowed to hear anymore?
Chantel from Newcastle, Australia. Great question. Let's put you on the map. Should we let's get to the question first. When an objection is made, and I think what you're saying is when the objection is sustained. So sometimes they'll go, Your Honor, objection, hearsay, sustained, motion to strike, stricken is sometimes what you'll hear the back and forth. Or the judge may say that testimony is stricken and I'm going to instruct the jury to disregard the answer. And you ask an excellent question. How do they do that? They can't just hit, the select all delete button in their brains and eliminate what they just heard. In fact, I've always been of the theory that when you tell them disregard something, they're probably going to think about it more than they would have otherwise, right? It's like the old mental experiment of say, don't think of a purple elephant. And the first thing you start thinking about is a purple elephant. How do you undo what is our natural part of our brains is to pay attention to the thing somebody says, don't pay attention to. You're sitting at lunch with somebody and you say, don't look now, but right behind you. And the first thing they do is go, where? So how do you do that with jurors? The answer is you can't really, right? I think more than anything, what you're telling them is I'm telling you that's not something that you can rely upon. Do your best to not rely upon it. Do your best to not disregard it. But certainly when you go back into the jury room and you start deliberating, remember this, that if that does come up, that I'm instructing all of you to tell each other that is not something that you should consider. Do they do that? You hope so. Do they always? Who knows? It is difficult. Now, where it becomes a real problem is when something super important might have been said. And then you start to get the arguments from attorneys saying, Judge, you can't unring that bell. How do you tell them to possibly ignore this shocking piece of information that they never should have heard, that is going to fundamentally affect the way that they view the rest of this case? That can, and there are instances, though rare, can lead to a mistrial where something so important has been said that should not have been said. There was a case recently where an officer said that he was unable to interview a person because they refused to speak with him. And that was seen as referencing a person's right to remain silent, and how that can appear as though that person's got something to hide. And there is a long line of case law and precedent saying that you can never reference a person's invocation of their own Fifth Amendment rights is a right that should not be both a shield and a sword. And if you do reference that, that could be grounds for mistrial. And I forget what case this is, if anybody listening remembers, but the judge granted the mistrial. And that's going back to trial again because an officer talked about the invocation of somebody's Fifth Amendment rights, and somebody's refusing to answer questions, and somebody saying they didn't want anything to say to the officer, and that was somehow could be construed as an admission, at least implied admission of guilt. That's the kind of stuff that you can't unring that bell. And it does cause problems. And even in these situations where the judge says the testimony stricken, move on, that's going to become an issue on appeal. Will the appellate court take a look at that stuff and say, hey, there's no way you couldn't expect that jury to disregard it? Who knows? Those will be questions answered later on. Great question, though, Chantel. And something, you're right. It's just kind of this, sometimes it's a construct that we just all have to live by in order to get these cases handled. And otherwise they'd never end. But to your other question, did you actually win an award, Ritter, or are you just saying that? I want to fact check you on this one. I actually did win an award. Here is Josh Ritter from 2015 at a banquet for the Outstanding Prosecutor Award for my time when I was at the LA District Attorney's Office. I got a little plaque. There's the plaque. It was awarded by the Association of Deputy District Attorneys here in Los Angeles. 2015. They don't hand out a lot of awards for defense attorneys. And I left the office right after this. Oh, and look who else was there with me in 2015. But my beautiful bride, she didn't know it at the time, but she was going to mother three children with me in the coming years. But yeah, it was funny. I got that award in, I think that was in October. And then I put in my resignation letter to the DA's office in November. It's like, give me my award. Now I'm out of here. But yeah, there you go. I am an award-winning prosecutor of the year for the LA District Attorney's Office, at least in 2015. Maybe I've lost a step or two in the, what are we now? 11 years in between. Good grief. Now I feel old. Thank you, anyhow, Chantel from Newcastle, Australia, for asking the question. Thank you for the kind words, everybody. All right, Heather Cooper Smith, thank you so much for the super sticker. So very kind of you. Rachel DeBruler, pardon me. Thank you. Says, morning, Josh and all, making the kiddos Swedish pancakes while listening. Thanks to kind person who gifted the membership. I'm so juiced. Oh, good. You got a membership. I love that. And Swedish pancakes, is that the kind where you just kind of throw all the batter in a pan and then throw it in the oven and it kind of puffs up? Or is that a German pancake? I'm not sure. I think that's the one where you just kind of mix all the batter, throw it in a pan and throw it in the oven and it puffs up into this. Come on, Kaylin, you're the baker. You know what a Swedish pancake is. She's saying, give me 1 minute, Ritter. I'm going to look up Swedish pancake. And then Gabriel, the Magalore, Maine, says, hello, I was wondering your thoughts on felony murder and if you've ever had that as a case. Mine have changed over time, but I'm still conflicted. Thanks. Gabriel, interesting question. So felony murder, just really quickly, is the idea that if you commit murder in the course of another serious crime, the R word, residential burglary, armed robbery, kidnapping, and somebody dies. You're committing that crime and somebody dies. It's about substituting intent. So we're saying that if you had the intent to commit the R word, kidnapping, residential burglary, armed robbery, and you can't just then argue, I didn't have the intent to kill. I only had the intent to kidnap this person. I only had the attempt to rob this person at gunpoint, but I never really intended to kill anybody. Felony murder says, no, no, no. We're going to substitute your intent for that crime because it's so inherently dangerous for the intent to commit first-degree murder, and we're going to charge you with first-degree murder. And people who are involved in the commission of that crime, if you are the lookout during an armed robbery, you can also be hooked in for that murder. And it's become a little bit controversial because some people feel like, oh, this is being used to put a poor guy who didn't know what was happening and he just happened to be driving the car and he got roped into the whole case. And now he's looking at first-degree murder. It's never really used that way. It's used rarely for other people involved in the crime. And it's usually people who are very well aware of what kind of crime they're committing. I think it's a powerful tool. I think it's makes logical sense from a criminal perspective, but I know that a lot of legislatures nowadays seem to be trying to peel away at it and chip away at it. But thank you, Gabriel, the Magalore, Maine, for asking the question. All right. Swedish pancakes look like crepes. Oh, they're just very thin. Okay, well, still sounds delicious, and now I'm hungry no matter the case. No matter where the pancake is from, now I want pancakes. All right, let's keep it rolling here. Wait a minute, what am I doing? Don't skip one, Ritter. Okay.
Hello, everyone. This is Kristen from Edison, New Jersey calling in. This is the first time I'm ever calling in, but I do listen to you religiously. I'm calling because I need to know what you think the motives are behind Kouri Richins' wild facial expressions. At this point, I fully believe that they are a defense strategy, whether it was her idea, which I very well think it could have been her idea, or her attorney's ideas, which I also think that they would think this would work. But I think they think that if the jurors are listening to testimony and then looking at Kouri's face and seeing her have these reactions, that they might believe that what the witnesses are saying is really not true. Because if I'm sitting in a jury box and I'm watching the defendant and I'm listening to the witnesses say certain things and the defendant is having a very expressive look on their face, I might believe the defendant's concern about what this person is saying. So I don't know. I can't believe that the judge has not admonished her for this, because I really think that it is very misleading to a jury when you do something like this. And if attorneys shouldn't be allowed to make faces or have reactions, then I don't think the defendant should either. And I just don't know why the judge hasn't said anything.
Kristen, first-time caller. Love the first-time callers. Thank you so much, Kristen, from Edison, New Jersey, for calling in. And it's a great question. Talking about Kouri Richins. A lot of people were talking about this. Kouri Richins' face seemed to be the co-defendant in this whole case. There she is. There's a good one. Good job, Kaylin. There's a good one. She did a lot of this. She kind of couldn't help herself. First of all, there's no rule There's no rule that says the defendant has to sit there stone-faced through the whole thing. There's no rule that says the attorneys have to sit there stone-faced through the whole thing. I know that Nestor brought this up as an objection, saying that the prosecution was making facial expressions during the trial. Again, I think that goes back to my earlier point about her being kind of concerned with the public perception of this case, because they were apparently watching the video and saw the facial expressions, because I don't think it was something where they looked over at counsel table and saw the facial expressions. I think a judge can admonish when it becomes overboard, outrageous, or most importantly, looks like they're trying to communicate something to the jury. But if a person's sitting there and they're reacting to something, and they raise an eyebrow, or they look aghast, or they, look intimidated or bothered, whatever, I don't think a judge is going to do much unless it becomes distracting. And if your question is, was it pre-planned? I mean, obviously we don't know. I don't know. I think it would be a really foolish mistake strategically if it was. Jurors, in my estimation and experience, are not going to look at the defendant reacting and go, oh, I find what this person just said on the stand to be suspicious. I think it might work the other way. If she's doing one of these faces or the previous one to somebody, they might start paying more attention to what that person on the stand is saying, because obviously it's getting to the defendant. In fact, if anything, if I'm telling my client, I'm saying, especially during testimony of people that I might feel like would be a little triggering to my client, I'm going to tell them, I've done this. Behave yourself. You cannot react to this. If you start acting like you're bothered by this, the juror's going to know that it's important. You need to act like this is the most boring testimony you've ever heard in your whole life. I do that. I used to, I should say, do that myself. If I was sitting there as a prosecutor and a witness was really giving me a hard time, maybe it was my own witness who is just falling apart on cross-examination. Maybe it was one of their witnesses who was just ripping me apart my case. I'm not going to be sitting there looking panicked and reacting to the whole thing, furiously taking notes. I might even put down my pen and look about as bored as I possibly could. You know, looking at my watch, maybe busting out a menu from a local sandwich place. What am I getting for lunch? I mean, the last thing you want to do is telegraph to the jury that this is somehow important or bothering you, or now I think she's doing this because she's finding the testimony to be incredulous. I don't think it scored any points. Obviously didn't affect the jury in this case. And if anything, maybe they had a talk with her. If they told her to react, I think that was a huge mistake. But I think if anything, they told her, kind of just behave yourself over there, Kouri. Just look like you're not bothered by most of this. But I don't think she's the type of person who can help herself. Kristen from Edison, New Jersey, thank you so much for the question. Great question. Thank you for calling in for the first time. Appreciate you being a part of the conversation. All right, let's keep it rolling here.
Hi, Josh. This is Tracy from near Seattle, Washington. I'm called last week and left a voicemail about this particular court case, but it didn't make it onto the Sunday Fun Day this weekend. So hopefully my second attempt will provide an opportunity for you to address the issues. I'm calling in regards to the Ramzi Khalid Ismail, aka Johnny Somali trial being held in South Korea. He's an American IRL streamer who's on trial for 8 charges. He's facing probably about 3 years in jail with labor and 150,000 won fine and registering as a S offender in South Korea, which would also trigger him being able.
Oop. I think we lost your audio, even though your message kept on playing there. So sorry about that. But I think I got the gist of your question. Tracy from Seattle, let's put you on the map. Great question. This is one that I haven't followed all that much. I hadn't heard of this one either before Tracy pointed it out to me. I'll be honest with you. He just sounds like an idiot and like a creep and like an unfortunate part of this modern society where clicks and eyeballs and viewers and all of that can get you money. And whenever there's a way to get money and you find out that the more and more outrageous your behavior is, the more and more that you're going to try to be outrageous to get clicks and money. And he's a troll. It's self-admitted, by the way. I don't know anything about the guy, but just what I've read about him, this is exactly what he does. So what he does, he's a live streamer. His name is Ramzi Khalid Ismail, but he goes by the name Johnny Somali. I don't know what his history is, where he came from, how long he's been doing it, but he's realized that one of the things that will get him lots of clicks and interaction and therefore probably money. By the way, if there was no money in this, he wouldn't be doing it, right? It's all about clicks and viewers and all of that stuff, but as long as that's paying the bills. So he'll go to other countries and just insult their culture and their race and their history. He went to Japan, and these are reports that I read, and he starts yelling at Japanese people on the street, Hiroshima and Nagasaki will do it again, while he's videotaping it and live streaming it. And there's a bunch of people online, I'm sure, who are going, oh my God, that's so funny. Keep going. A bunch of kind of other trollish type people. Maybe he even gets a lot of hate from folks saying, I can't believe you're doing this. This is awful. But still, those are eyeballs and interactions and probably gaining him more money. He went to South Korea and he started playing speeches by Kim Jong-un, who is the dictator ruler of North Korea, obviously not all that friendly to the people of South Korea, and started playing speeches by him loudly on the subway in South Korea. Then he went to a memorial for victims of sexual exploitation during World War II in South Korea. And, oh, there he is, desecrating it, mocking it. I think he actually did worse than what we're seeing here in this picture. The guy's awful, but it's all for clicks, right? It's all for do you want to call it clout? I don't even know if that's the right word for it. Well, you know what? He's probably used to doing that in the US, where we've got very strong First Amendment laws, free speech laws. You go to a place like Japan or South Korea, they don't have the same laws. And so they arrested him. And he had several trials, actually, but his last trial started in August of last year. And he actually pled guilty to several counts. I'm not sure the legal strategy or all the twists and turns behind all of it. But now this idiot is looking at 7 years in prison, which, by the way, they have something in South Korea called labor. While you're in prison, you can be sentenced to labor, not just sitting in a jail cell. 3 years of that could be labor sentence. And his sentencing is going to take place in April. So if you're really curious, Tracy, keep an eye out for this case in April, coming up here in less than a month. April 15th, he's going to be sentenced. So he'll see. We'll see if all of it was worth it to this guy. This is the kind of stuff that is wonderful and is incredible as YouTube and the other platforms can be. And listen, I'm sitting here on YouTube lecturing us all about this. I'm obviously a big fan of YouTube. I think it's an amazing thing. I think we live in an amazing world where with a computer or iPhone or smartphone with a camera and an account, you can log on and start speaking essentially to the entire world. I mean, this channel, this show that we do is an incredible demonstration. You see the map of people and callers all over the world. That blows my mind that from my tiny little spare bedroom here, we can be talking to you and sharing conversations and sharing thoughts and chatting with each other from people all over the world is an amazing, beautiful thing. But it also can be an environment that can create a gentleman like Johnny Somali, who decides to go to different places to insult people so that he can get a bunch of clout. There you are, Tracy. That's the latest on that case. All right, let's keep it rolling here.
Hey, Josh, Tiff, Kaylin, and everyone on the Courtroom Confidential crew. Hope you're all good. Cat Flap Carnage here. No longer in Stilton, now in a smaller village called Ramsey 40 Foot. Challenge you to find that if you can. It's just a quick question, so it doesn't matter if you don't get to read this one. I totally understand. Watching all these legal dramas and things, I often hear about a term that says fruit of the poisonous tree. What is it, and is it real? Is it something a real judge would use in a courtroom situation? Hope everyone's good and enjoy your Sunday fun day. Thank you.
CFC, Cat Flap Carnage from, and can Kaylin find Ramsey 40 Foot, England? Ha! Ha! Child's play for Kaylin. Of course we found it. We're putting you on the map. Thank you so much, Cat Flap Carnage, for calling in. I think I've asked you before, but I really would love to know the genesis of that name, Cat Flap Carnage. And a great question. What is fruit of the poison? I've just heard this term this year, says Chicago Marie. Fruit of the poisonous tree. What does it mean? Is it actually used by judges? Yeah. It's referenced in court all the time. This is fruit of the poisonous tree, Your Honor. And it's shorthand for essentially this concept. When we're talking about violations of the Constitution, specifically and most commonly the Fourth and Fifth Amendment, usually mainly the Fourth Amendment. Fourth Amendment deals with your right to be protected from unlawful search and seizure, right? Warrantless search and seizure needs to satisfy certain elements of probable cause, okay? What do you do if that's not satisfied? If the police search you, take something from you, and they did not have proper probable cause, and they didn't have a warrant, and therefore it's a violation of the Fourth Amendment, what do we do with that? Well, in the case law that has followed, it's not in the Constitution, it's not in the amendment, but in the case law that has followed, we've come up with what's called the exclusionary rule. And it's a bad one. If you violate the Fourth Amendment, one of the things a judge can do is exclude that evidence. So you arrest a person, you pulled somebody over, you had bad probable cause, you had no reason to pull them over, you had no reason to pull them out of their car. And when you found the gun that was used in the shooting of a murder on that person, and you didn't have probable cause, and you illegally searched that person and illegally searched that gun or seized that gun, you're not going to use it. We're going to exclude that evidence. Think about how hurtful that is to that case. Think about how impactful it can be to that prosecution. And the reason for that is it's kind of like a lesson learned for law enforcement. Don't mess it up, because this is the consequences. You can lose an entire case based upon bad police work, not having proper probable cause, not following the rules, not doing things appropriately. Now, whenever you got a rule, what do you got? You got an exception. Well, to get to the fruit of the poisonous tree, though, it means anything, any secondary evidence from that, any derivative evidence from that. So what could that be? Maybe you improperly arrest someone and don't properly advise them of their Miranda rights, and therefore, when they told you where the dead body was, you cannot not only use their statement as a statement against them, you can't then use the discovery of the dead body against them, and any evidence gathered on the dead body can't be used against them because that's all secondary derivative evidence. And the shorthand that we have for that is fruit of the poisonous tree. Your Honor, if they messed up at step A, they don't get the benefits of the evidence that they found in steps B, C, and D. It's all derivative. It's all fruit of that poisonous tree. The way that they started this all off was illegal, and so therefore they shouldn't benefit along the way. Well, whenever we've got, is this like Mangione search of the backpack, right, Josh? Yeah, like if they didn't have proper search to get into the backpack, then they don't get the evidence inside of the backpack, and they don't get any evidence then derived. Here's an example. So let's say they find the journal, right? The journal's evidence that was illegally seized, let's say. I don't think that's true, but using this as an example. Then if inside the journal, they find other evidence, they find, and hey, by the way, I stored another weapon at X location. When they find that weapon, that would be derivative, right? You follow me? It's evidence that is secondary, evidence that they gained from that first piece of illegally seized evidence. That would be considered fruit of the poisonous tree. But like in anything, there's exceptions to this. One of those is independent source. So if someone else tells you, hey, I know where so-and-so stored the body, that's independent source. Inevitable discovery can be where, yeah, there we go. Afton, always ahead of us here. When she's not feeding horses, she's studying case law. Inevitable discovery can be, hey, we were doing a grid search of that field where the body was discovered anyways. We were going to find it. It was an inevitable discovery. Good faith exception can be one too. Maybe the police thought they had probable cause. They had a warrant and they were acting in good faith when they executed this search because they had a warrant. They had done everything right and the warrant was flawed for whatever reason. You know, think of some reason that wouldn't be all that fundamentally bad. It was filed with the wrong court in the wrong jurisdiction, you know, some sort of logistic issue with the warrant that makes the warrant invalid, but the police were still operating in good faith. That can be an exception as well. So where was I going with all this? Oh yeah, fruit of the poisonous tree. Yes, a very real concept, very important concept, and definitely used. Nobody's making it up. There you go. Cat flap carnage from Ramsey 40-foot England, everybody. Eroy, thank you so much. Says, I think I remember the fruit of the poisonous tree can be bypassed if it was more likely than not that they would have found the evidence somehow anyways. The Brian Walsh case. Yeah, that's where we're going with this kind of inevitable discovery. They were going to find this evidence anyways, and they got it to it quicker because of this other evidence that kind of gave them a short circuit or shortcut to getting the evidence, but they would have found it anyways. Inevitable discovery, or somebody else independently told them about it. That's a good point too. It doesn't make the evidence excluded if you had other sources giving it to you. It's just this one source happened to be bad. But great point, Eroy. Thank you for bringing that. See how smart everybody is? We're going to do a whole show once where you all answer the questions. Wouldn't that be fun? I'll ask the question and then we'll just crowdsource the answers. Mimi D1 has been a member for 13 months, everybody. Best true crime channel ever. I'm not going to disagree with that. And thanks for keeping the lives ad-free, says Need More Vampires. Thank you for that. Thank you for pointing that out. That is something that we've dedicated ourselves to, is that if you're watching this live, we're not going to let YouTube interrupt it. So we appreciate all of your kindness and support. Point in fact, Derek Sherman, thank you so much for the super chat, says, Josh, in my opinion, Kouri was 100% guilty. The prosecution's closing arguments was a slam dunk. The defense ladies needed to try using the you catch more flies with honey than with vinegar. Her lawyers didn't help the case. Yeah, I know that they've received a lot of heat and criticism. That I think they rubbed a lot of people the wrong way. I don't know, though. How much honey would you have needed in this case, right? I don't even know if the best attorneys could have really done all that much, but it did seem as though I think her attorneys, and this is kind of a syndrome, an itis that sometimes happens with the defense attorneys. They get so kind of bothered and beaten down before trial. They feel like this judge is against them. Everything went their wrong way. They didn't get the change of venue. This judge is allowing in the walk the dog letter. This judge is not giving us anything. And they become so kind of just blinders on to it's us against them that they can't turn that off when they're in front of a jury. And it kind of bleeds through even the way that they conduct themselves in court. And then they look angry and upset and bitter and overly sarcastic and overly bothered. And yeah, I agree with you. They probably didn't do their client any favors. But again, you're going to need an awful lot of honey to have done much different in this case. But thank you so much, Derek Sherman. All right. Get it together, Ritter. Where are you? Keep it rolling. Here we go. Here we go. Oh, Kaylin's going to yell at me.
Hello, Joshua, Empress of CC, Tiffany, and her lady-in-waiting, Kaylin, and the best mods in the whole world, and CC family and guests, Alicia K. Mayo in Humboldt, Tennessee. So I'm going to try this again this week, Joshua. No, I'm not picking on Kathy Nestor, but I'm kind of picking on Kathy Nestor. I'm wondering if some attorneys get flustered if they're in a small courtroom, and conversely, can they get flabbergasted if they're in a large courtroom and cause them to make, let's just refer to them as unforced errors, Joshua? And on a side note, would really love to see on a Members Live you play some of your instruments, Joshua. Would love to know about that talent there. Hope everybody has a great Sunday fundy. Thanks, y'all. Bye.
AKM from the now famous Humboldt, Tennessee. Thank you so much, Alicia K. Mayo. Always love to hear from you. The question is, not picking on Kathy, but kind of picking on Kathy. Does the size of the courtroom affect attorneys? Really interesting case, something I've never thought of. My first answer to you is this. If it does, then you're not a very good attorney. Like, I really feel like if you need the perfect kind of environment, then you might not have a great case and you might not be that great of an attorney. And I'm trying to think just back in my own experience. I've had trials in very large courtrooms. I've had trials in very small courtrooms. I've done a trial online. I mean, you want to talk about being thrown off your game in an environment that you're not used to. Try doing a trial sitting in front of your laptop in the conference room of your office while you're calling witnesses and cross-examining people and dealing with the judge. So was this courtroom environment maybe something she's not used to? Well, I think she practices in that county fairly often. She should be used to those courtrooms. But, I mean, everybody likes to feel comfortable. I imagine if I was in a courtroom once where it was so small that it was like everybody was on top of you. Actually, I was in a courtroom once that was a converted trailer. Talk about not the most friendly of confines. But yeah, if people are kind of on top of you, you feel a little more. I think that where I felt most kind of self-conscious about it was I didn't want people looking at my laptop, what I got on my screen, or looking at my notes. And when people are kind of like, you feel like they're breathing over your shoulder. But again, if you can't adapt and get it together and service your client or service the people of this great state of wherever you happen to be, because the courtroom's affecting you, look into a different profession. Try YouTubing. All right. Thank you so much, AKM. Let's keep it rolling here. You guys liking this? I think we've got some great questions so far, right? We've been all over where have we been? We've been all over the country, all over the world, including Saskatoon, Saskatchewan, Canada, Newcastle, Australia, New Jersey, Ramsey 40-foot. We've been, look at that map. Incredible, you guys. And we've had a lot of great questions. We talked about Kouri, we talked about Kathy, we talked about Fruit of the Poisonous Tree, Johnny Somali. Now you guys all know about him. You can follow his YouTube channel when he gets out of prison in 7 years. We've done some great stuff. You guys have really pulled it through. All right. Hush up, Ritter. Get to the next one. Where are we off to here?
Hi, Josh, Tiff, Caitlin, Mods, and CC crew. This is Little Miss Red Velvet from Manchester. We've been watching the Kouri Richins trial every day on CC Live Trials, although I missed the verdict due to the fact that I went to sleep. As you know, we got a guilty verdict. Now, I'd like to ask some questions about the jurors. How do you pick the alternates and why have them? The jurors' notes taken during the trial, what happens to them? Why do they poll the jurors at the end? And with jury selection, what kind of questions do you ask if A, the defense, and B, the prosecution? Look forward to seeing you on Sunday Funday. Take care. Bye.
LMRV from Manchester, England. Let's put you on the back map. Always great to hear from you. And you ask, I love your rapid fire way. You get a lot of questions in there, and they're all really good ones. They're so good that they had me a little bit stumped. But you know what? Doesn't matter. You can't stump me here on Courtroom Confidential, because even when I feel like I might not be qualified to answer the question, I can. Always. Kaylin, please remove the map. Oh, phone a friend.
Hello, Attorney Eric Faddis, the Mile High Lion. I am headed out for a California vacation, but I wanted to answer Little Miss Red Velvet's questions about the Kouri Richins trial. So her first question was, why do they select alternative jurors and how do they do that? So the reason they do that is because sometimes during deliberations, these folks have life stuff that comes up. There could be a family emergency. They could get sick. And so they need someone to sort of jump in and continue the deliberation so they can reach finality in the verdict. That's why they have the alternates. How do they choose them? It's usually random. And it's kind of a bummer for these folks because they're told at the end of the trial, hey, you've sat through this whole thing, you become invested, and now you don't get to decide it. Secondly, you asked about juror notes. What happens with those? Those are destroyed to protect juror privacy. Third question was, why do they poll the jury? So that's when they go juror by juror and they ask, hey, was this your verdict? Did you truly vote guilty? One reason they do that is because there can be pressure back in that deliberation room, and they want to ensure that the verdict they reach was the true expression of each individual juror. Lastly, jury selection. What does prosecution want? What does defense want? Generally speaking, prosecution is often looking for folks who are like law and order types, right? So like police, prior military, who are going to kind of go by the book. The defense, however, often wants the outcasts. They want the rebels. They want folks who are going to go against the grain, who might challenge the government's evidence and not just completely accept it. So I hope that's helpful. Thank you for those questions, and have a great rest of your day.
That is Eric Faddis, everybody. He's an attorney in Colorado. He's a great guy. We've had him on the show before. There's his law firm, ericfaddislaw.com. Please check it out. There's his Instagram. Go give him a follow. Tell him hi. Tell him thank you so much for being on here and answering the question. He was just kind enough to peel out some time during his day to answer this question for us. And it kind of cracked me up because it looked like in this video here that he was kind of answering our question before he tried to sell us a house. Like he's on his real estate, his part-time job on the weekends is doing real estate. And he's like, great question, Little Miss Red Velvet. Now let's step inside this 2-bedroom and 2-bathroom bungalow that's for sale here. I don't know why that was the first thing that struck me, but thank you, Eric. He's a great guy. You guys should send him some love if you get the chance to. And there's the answer to your question. Hopefully, LMRV. Yeah, alternates are important because we don't want to be starting trials over just because somebody got sick or the trial went a little bit long. So we have kind of backups ready to step in, and they never know when they might be called. I've had it happen all the time. I had a trial where we nearly ran out of alternates. So they get used. They think that they're never going to be used. They get used and they have to pay attention. Jurors' notes are destroyed afterwards. And I love the way he answered the question. That's basically true, is that you're looking for people who, are kind of a personality type. But what I always say about jury selection, it's not jury selection, it's jury deselection. More than anything, you're looking for the people that you want to get rid of rather than the people you want to keep, because you don't get to say, it's not a draft, right? It's not like I say, I picked juror number 1, Your Honor. You're kicking people off. You're not selecting people. So you're more thinking about who do I want to get rid of more than you're thinking about who do I want to keep, because the other side is usually kicking off the people you want to keep anyways. And he was a guest on Joe Patuto's channel, so check him out over there too. Great guy from Colorado. Check out his law firm. Thank you so much, LMRV from Manchester. All right, let's keep it moving along here. Oops.
This is Sonia in Chicago, and forgive me, but I am calling about Miss Daisy Link. So I have been watching a couple different YouTubers, Kathy from A Gossip, Rumor, and Innuendo, talking about Miss Daisy Link and how she might not belong in jail, actually, which is very interesting. So is there any way that we can talk about Daisy Link and that she's getting a new trial? I'm kind of excited about it now that I know more. Without even going, near the pregnancy stuff, just her trial alone. It's pretty wild. Okay, just curious what you guys think. Thanks for being awesome.
Sonia, Chicago, Illinois, one of our mods. Let's put you on the map. There you go. Great question, Daisy Link. I love how you say, without even getting into the pregnancy stuff. I don't think we could talk about Daisy Link with at least about referencing how it was in the world we even are talking about this poor lady. She landed on the true crime radar several months ago this was actually it was a year or so ago. I think she's in jail for murder, awaiting trial. While she's awaiting trial, she starts a romance with another person who's in jail. And apparently they are speaking through the air vents. Somehow these two lovebirds, these two star-crossed lovers, this jailed Romeo and Juliet decide that, hey, wouldn't it be a great idea while you're in jail if I were to get you pregnant? And Daisy says, yeah, that sounds like a wonderful idea. I can't think of a more responsible thing for me to do while I'm awaiting trial for murder. But they can't physically do it. So, graphic warning here, he transports his baby making, what do I call this? He transports his the gentleman's side of the process in saran wrap. Oh, gossip rumor just showed up at the perfect time. I should have her explain it all to you. Kathy would do an excellent job of explaining this all to you. He transports it in saran wrap through they tie it to a line made with bedding, and he transports it down to her genetic material, says Farm Girl. Excellent. He transports his genetic material wrapped in saran wrap using a rope made from bedding down to her jail cell, and then she applies said material to herself using a feminine applicator and gets pregnant. Miracle of miracles, the miracle of life. Gets pregnant while in jail and gives birth to a baby girl in June of 2024, who is then, I think, in the custody of either her parents or his. It's just people who cannot help themselves from continuing to compound errors and mistakes that they've made in their lives. Let Kathy explain this. Yeah, we'll have to bring Kathy on just for a special episode of explaining this one to all of you. Yes, this really happened, Afton says. Yes, it did. Well, then after that whole, hallmark moment, she does have to go to trial, and she's convicted at trial for the murder of her husband, by the way, who she shot, but then claims it was self-defense. Now, the reason we're talking about it and that Sonia is asking about it is apparently in closing arguments, and this one drives me nuts. In closing arguments, the prosecution entered photos in their closing arguments that had not been entered into evidence during the trial. That is my understanding of it. This is Judge Lodi Jean's comments on that. The photos came at a critical time in the trial during the closing argument, which was almost impossible to rebut. That being important. If there were photos put in, even improperly admitted in front of the jury, at least there would have been an opportunity to do something about it if the trial were ongoing. But in closing arguments, it's almost impossible to rebut. Not only was an unadmitted evidence presented to the jury, but it was also coupled with argument used directly to discredit Link's, Jody's, self-defense claims from a key witness in the case. So apparently her mother had testified to like the condition of the house, and they showed pictures rebutting that during closing arguments rather than during cross-examination of her. Apparently a lot of people are Team Daisy. I don't know enough about this case to really weigh in on the actual substance of the crime, of the evidence against her, but I can weigh in on if it is true that prosecutors, having been one myself, used photographs to rebut a prior witness and made argument to that point for photographs that had never been used during the trial, never admitted into evidence, and never confronted the actual witness with that. I do have a problem with that. I have a problem with that kind of behavior on behalf of prosecutors. And if the judge decides, and by the way, what's happening right now is the prosecution is appealing the decision by the trial court judge. So it's the trial court judge who's granting this new trial. This wasn't on appeal by Daisy. It was the trial court judge that they made the arguments in front of, and the judge said, well received, I'm granting you a new trial. And now that decision is being appealed to the appellate court on whether or not she should get a new trial. Hope that makes sense. Hope you guys can all follow that. Yeah, that was one of my proudest moments there. All right. Great question though, Sonia. Thank you so much for bringing that up. It's an interesting wrinkle in that case. And we will, if that case needed any more interesting wrinkles, we will follow that and keep you guys all updated. All right, let's keep it rolling here.
Hey Josh, Tiff, Kale, the best mods on YouTube, and of course the CC fam. This is Eroy calling from Cape Cod, Mass. And I'm watching the final trial readiness hearing for the Kelsey Fitzsimmons case, and they just announced that it will be a bench trial instead of a jury trial. My question is about the appeals process in a bench trial. In jury trials, we often hear about the appeals being based on things like evidence rulings, sufficiency of the evidence, abuse of discretion. But in a bench trial, it seems like the judge is going to be making those evidentiary rulings and also deciding guilt or innocent. So if the defendant is found guilty, how does the appellate process work differently? And is it harder to appeal when the same judge is both the gatekeeper of the evidence and the finders of the facts? Thanks. Love the show.
Eroy, so good to hear from you. I finally worked up the nerve. I'm glad that you did, because this is an excellent question. First of all, I want to thank you again for gifting those memberships. That is so kind and generous of you. And I want to thank you for calling in. It's so great to hear from you. And this is a great question. We've got the smartest community on YouTube, everybody. I love, by the way, Eroy saying at the very end there, is it when they're both the gatekeepers of the evidence and the finders of fact? You sound like a lawyer saying that kind of stuff. I love it. And it's a great question too. Is it more difficult? Are there more problems? Are there less problems when it's a bench trial as opposed to a jury trial? Interestingly, I think that it probably is not affecting the appeals as much as you might think. Here's the reason for that. In a bench trial and in a jury trial, the judge is still the gatekeeper of the evidence, right? The judge is still making decisions about what evidence will come in and what evidence will not. The big difference, though, is that the judge is aware of the evidence that's not coming in, right? If you're making an argument of, hey, Your Honor, we want to admit the walk the dog letter, and we feel that part of this letter is inappropriate evidence and part of it is appropriate evidence, and the judge rules, yes, I'm going to admit parts A, but not parts B, C, and D. In a jury trial, the juror never becomes aware of that inadmissible evidence. In a bench trial, the judge is aware of it. So how do they distinguish that? How do they work that gymnastics in their mind? Well, they do, and they have to, and they figure it out. But the problem is, how do you appeal that? You can appeal the ruling. You can say that it was inappropriate for the judge to exclude part or to include part. But how do you appeal the judge being aware of it? And you can't really, okay? I hope I'm making sense on this. What is appealed at trial, in an appellate court, are legal rulings, not even the findings by the jury, right? If a jury, you're not appealing the fact that the jury found a person guilty. You're appealing the evidentiary rulings made by the judge that resulted in that guilty finding. But you can't say, I don't like that they found my client guilty, therefore I'm appealing it. Same thing with a bench trial. You're appealing the decisions made by the judge, but not maybe the ultimate decision on guilt or innocence made by the judge. But you're right. There is kind of a, we talk about what we ask jurors to do. Well, you're even asking a judge to do more by both being an impartial finder of fact and being the person who's deciding, calling the balls and strikes on what comes in. Now, I think we all kind of go, well, we're willing to take that risk because, and I imagine in this case, the situation is it's much more of a legal argument being made, and it's not so much of a factual argument that we're concerned with. So we're not all that bothered by what facts the judge may or may not know, but really we're more concerned with the law. But I've got to say, it's a little surprising to me that they did ask for a bench trial in this case. But great question, Eroy. So glad that you called in. And I think, again, we have won this week's prize for the smartest community on YouTube. So thank you so much for that. Therapist says, thanks for all you, Josh, and CC crew learning so much every week. Oh, well, that makes me feel very good. I'm glad to hear that. Unholy Saint says, listening during my drive through Vegas. Oh, been a member for 2 months. Are you at long, like a trucker? I see the truck there. Oh, I would love that. I would love to know if there's a trucker who listens on live. That's fantastic to me. And if please don't text while driving. But if that is true, Unholy Saint, I am thrilled by that. And then Evangeline Light has been a member for 7 months. Everybody says, learned so much here, and your wife is adorable. She is adorable, and I'm glad that you learned so much here. And one of the things that you've learned is that my wife is adorable. So there you go. All right, let's keep it rolling here.
Hey, Josh, Mike from Cleveland here. Got a wild question for you this time. After watching the Kouri Richins verdict and people discussing the relatively short jury deliberation time, my mind took me way back to 1995 and the O.J. Simpson trial. I know that's the wrong kind of juice. So after what was a really hard to believe 9-month-long trial that I think I watched every night after work, the jury deliberated for less than 4 hours. I think it's well documented what most of us think about that verdict, but it made me think of something. And you can't see my eyes rolling as I say this, but since technically the killer was never found, wouldn't this still be a cold case? Could they use like today's advanced DNA testing and all the evidence they collected, like the glove, the inside of that glove maybe, to see if they could get a positive match? Even though he's since died, it could give some closure to Nicole and Ron's families, I would think, although they probably moved on. But do you think this would ever happen? Who would have to request it? Could the family do it, or is it up to the DA? Thanks, and keep up the awesome work.
Mike, one of my dudes, calling in from Cleveland, Ohio, and I love this question. Yeah. God, I know a lot of you followed that case, OJ, very closely. It's hard to explain what an absolute shock it was that after 9 months, they had a verdict the day they gave it to the jury. I mean, people were making vacation plans. People were talking about the weeks this was going to take. And they came back that day. It just blew everybody's mind. When we talk about quick verdicts, let's calibrate ourselves. This was one of the quickest verdicts in a case that everybody thought was going to take weeks, but that's a whole other show. Maybe we'll do a show on OJ. I'm still fascinated by that case. Anyhow, is it considered a cold case? Well, Mike, here's the thing. OJ was not found innocent. OJ was found not guilty. Is there a difference? Yes. Why is that important that there's a difference? Because in the law, we are not clearing you of the crime. We're just saying there wasn't enough evidence beyond a reasonable doubt to convict you for the crime. And there's a big difference between those two things. You don't walk out of court being an innocent person. OJ did not walk away from court being an innocent person. He was acquitted, but acquitted means he was found not guilty, meaning 12 jurors, and don't get me started on these jurors, but 12 jurors said that there was not enough evidence to prove that he was guilty beyond a reasonable doubt. That's different because that doesn't dictate whether or not the case is closed. The case is closed, okay? As far as law enforcement is concerned, this case is solved. Now, it didn't end up in a conviction, but there are no other suspects. It's not a cold case. They're not. You make an excellent point. How about they run the inside of the gloves to find DNA? His DNA was literally all over the place. His DNA was at the crime scene. Her DNA was in his house. Blood, you can literally, I mean, this case has more forensic evidence than most cases we talk about. The amount of blood that you can track both from the crime scene of the victim and the defendant back to the defendant, his vehicle inside of his house. Her blood, Nicole's blood, was found on his socks discarded in his bedroom of his house. One of the gloves that was used in the murder was found at the crime scene, and the matching glove was found at his house. This isn't an unsolved case. This isn't an open case. This isn't a cold case. This is a case that ended in an acquittal, which is very different. But great question. And important for us to remember, too, the difference between not guilty and innocent. In fact, I think in some jurisdictions in the world, they actually have an innocent, like a finding of innocence. That's not what he was found guilty of. And to that point, when the standard was lowered and he went on civil trial, he was found responsible for their murders. By a preponderance of the evidence, they found him easily responsible, and he was ordered to pay millions of dollars that he never ended up paying because he went off to Florida and then kidnapped somebody in Las Vegas and spent some time in prison. But like I said, that's a whole other episode. But great question, Mike from Cleveland, Ohio. Appreciate you, my friend. All right. Let's keep it rolling.
Hi, Josh and CC crew. It's Hayley from Cornwall, UK. I had a quick question about the Lockerbie case. There's still one person to go to trial, the bomb maker. I think his name is Masood. It seems like it's going to be held in Washington. I don't know if maybe that's it would be in the federal court. I suppose my question is around jurisdiction, because the original 2 people that went to trial that was done in Europe. I don't know if that was because it needed to be in a neutral place. But yeah, I just wondered if you knew when it was happening, why it was in Washington, and if I don't think we're likely to see it on the TV, but it's a real shame, because I think some of the parents and families and friends of them now will be quite elderly, maybe not be able to go to America, but let's hope there's some justice. Thank you.
Haley from Cornwall, England. Thank you so much for calling in. Let's put you on the map. Yeah, this is interesting. Somebody brought this up not too long ago, too. This is pretty fascinating. This is a case from the, oh, there you are. It's me. Thank you so much for the question. This was the deadliest terrorist attack in UK history. We're going back to 1988, the bombing of Pan Am Flight 103. December 21st, 1988, the airline blew up, bombed over Lockerbie, Scotland. 243 passengers plus 16 crew members lost their lives, plus 11 residents of Lockerbie, where it crashed. So 270 total fatalities. And it's had a long kind of history. In 2001, a person by the name of Abdel Basset al-Megrahi, who is a Libyan intelligence officer, was found guilty on 270 counts. His co-defendant, Famina, was acquitted. In 2009, Megrahi was released from prison. If you can imagine that, on compassion grounds. He had prostate cancer. And then in 2020, the U.S. indicted the gentleman that you referenced, Haley. His name is Abu Aguila Masood, who's a Tunisian resident and alleged to have been the bomb maker. And he actually confessed, according to prosecutors, in 2012. He was 37 at the time of the bombing. Trial is set, and it's actually going to take place in a few weeks here in 2026. But your question is an excellent one. Why, for a bombing that took place over Lockerbie, Scotland, are we trying this person who's a Tunisian in the United States? Well, there's a few reasons for that. One, it was a U.S. airliner. It was a Pan Am flight. Two, 189, I didn't realize this, 189 American citizens were on that flight and lost their lives. And there's two principles at play here that allow for U.S. jurisdiction in this case. The first is called the passive personality principle, a weird name for it. But what it essentially says is that extraterritorial jurisdiction to prosecute foreign nationals can be gained for crimes committed abroad against U.S. citizens. So by U.S. fiat, by UN Security Council resolution, and by certain treaties, we have essentially the understanding that if a crime is committed abroad against a U.S. citizen, that the U.S. will have jurisdiction over that. Another principle is called the protective principle, which where the U.S. asserts jurisdiction over acts committed outside its territory that threaten the security, government operation, or vital interests within the U.S. territory. So the long and short of it is the U.S. is essentially going to find a jurisdiction where they feel like they need to find it, even when it involves foreign nationals, and even when it involves crimes in other states, if the U.S. feels that it affects either the citizens or the national interests of the United States, and that the way that they're able to do that is through the cooperation of both the UN and other countries. So no one's throwing a fit about this. U.S. found this guy, indicts this guy, and they were happy to send this guy to the U.S. to be tried. And that will happen, I think, any day now. But you're right. It's going to be in federal court, so we're not going to have cameras, but we will follow it and update you all on this case that is now, what, close to 40 years in the making? Am I doing my math right there? Incredible. All right. Let's keep it rolling. Where are we off to next here? You guys having a good time? How juiced is everybody? I haven't seen that in a while. I haven't seen anybody check in on their Juice-O-Meter 2000 yet. Love to see that. All right, where are we at? Just hush up and answer the questions, Ritter.
Hey, Josh, it's therapist in West Texas. I'm confused about something. Sometimes we're told jurors should look at the totality of the circumstances, but other times, like with attempted M for Kouri, some attorneys are saying that charge should stand on its own and be evaluated independently. How do jurors know which approach to use? Thanks. Bye.
Therapist from West Texas. Great question. So it is sometimes easy to confuse what jurors should be considering and what shouldn't they be considering. And really here, it's entirely separate, kind of separate concepts dealing with separate things entirely. So when the defense is saying and making the argument that the crime should be considered independently, what they're trying to say is you cannot find Kouri, and this is true, you cannot find Kouri guilty of murder because you feel that she committed attempted murder. So let's say there was a situation where they felt that the evidence against her for the attempted murder with the sandwich on Valentine's Day was strong, but they weren't quite sure about the murder. You can't use the attempted murder as evidence of the murder. Now, as true as that is, and as independent as they are, it's also kind of not true, because the prosecution was arguing, well, that shows she was attempting to do it before, and therefore is reason to believe she committed the actual murder. But the concept of each crime being independent and needing to stand on its own is still true. Same if you look at it the other way. If they found that she was guilty of the murder, but weren't quite sure about the attempted murder, you can't just throw that in there like pocket change because you feel like, wow, she did the murder. She probably did the attempted murder. You have to find beyond a reasonable doubt that she committed the attempted murder as well. Now, if you want to consider the idea that the attempt was part of this grander scheme to kill him, which she eventually did, you can, but you still have to independently find beyond a reasonable doubt that satisfies all the crimes of each of those independent crimes. Now, as I'm saying that, I hope I haven't made it more confusing, but that's what where they were going with that. On a totally kind of separate issue is this idea of the totality of the circumstances. We use that when we're trying to judge things like probable cause, police, or the reasonableness of a person, right? When we talk about the reasonableness, a reasonable person standard, that is oftentimes something that's explained to jurors, say in a self-defense case. Was this person acting reasonably under the circumstances? Well, you have to consider the totality of the circumstances to understand the reasonableness, right? You can't consider a person shooting another person in a complete vacuum. You have to understand the relationship between those two people, the surrounding environment. Was this taking place at night? Had the person been threatening them ahead of time? Was anybody intoxicated? All of those surrounding circumstances create the totality of the circumstance in which you're going to judge that person by a reasonable person standard. So I hope that makes sense. Yes, no, nods from the audience. Yeah, okay. Caitlin's giving me those. It kind of made sense. Good enough for me. Good enough for me. All right. Nate Dogg is 1% juiced. Nate, I don't know what to tell you about that. It's like you're not even trying. It's like you're not even trying to be juiced. Hidden in the Shadows is 29% juice. Slightly better. 55% juiced. What is going on this morning? 66, Becky B, getting a little bit better. There we go. Black Witter is 99% juiced. Be like Black Witter, everybody. Get it together, folks. It's Sunday. All right. Teresa Walker, want to thank you so much for supporting the mods with coffees. Appreciate you. Everybody's just saying, get back to work, Ritter. Here we go.
Hi, y'all. Court Dog Daniel from New Britain, Connecticut. Josh, I really enjoyed your segment this week with Sky Lazaro after the Kouri Richins verdict. Watching her navigate questions about a former client while clearly respecting her attorney-client privilege and whatever conflict removed her from the case was fascinating to watch as a viewer. It actually also reminded me why I'm still so curious about why Alan Jackson was conflicted out of the Nick Reiner case. So I've got a couple quick questions about conflicts. What are the most common type of conflicts that arise for attorneys? And have you ever personally been conflicted out of a case? And have you ever seen or been a part of a case where a conflict was discovered late in the process, like maybe even deep into the trial? And if so, could that ever rise to the level of having a case overturned on appeal if the conflict was discovered after a verdict? Appreciate your questions. Your answers to my questions. As always, juiced.
You didn't give us our countdown to CrimeCon. I was looking forward to that. Court Dog Daniel, one of my dudes, CDD from New Britain, Connecticut. Thank you so much, my friend. Yes, we did have Sky Lazaro on. If you guys missed that, please go back and watch it. It was a really great show. It was last Wednesday, wasn't it? Just a couple nights ago. A lot of people enjoyed that. We are very grateful to her for coming on. As you may or may not know, Sky was Kouri's lawyer through much of the lead up to the trial, and then she had to conflict out. There she is in court, sitting next to Kouri. She actually handled the prelim. She was going to handle the whole thing, and then something happened where she had to withdraw as counsel. We talked a little bit about that with her on the show. If you're curious, there's only so much she can say about it because she's still under certain obligations as her attorney to not disclose attorney-client privilege things, and Kouri has not signed off on any kind of disclosure of any of that. Shy Gal says it was a fantastic show. It was really great. It was really nice she was very forthcoming, shared with us a lot of insights, I think, more than I was expecting, to be honest with you. And she's very kind to have spent the time with us talking about this case. But to your point, CDD, what are the most common types of conflicts? Are client conflicts, where you represent or you have represented someone that is somehow connected to the case that prevents you from representing your current client. Every person is entitled to a conflict-free representation. We saw this, I mean, most dramatically demonstrated in the Donna Adelson case, where what's his name? God, I'm blanking on his name. I'm bad with names, guys. He represented Charlie ahead of time, and then thought it would be Rashbaum. Thought it would be clever of him to then represent Mom. I don't know how he ever thought he was going to get away with that. And the judge was great in finally making a decision about it, but probably should have handled that much earlier on. But that's what is the most of the time what prevents a attorney from representing someone or creates a quote unquote conflict. And so we know that. And so we deal with that. We run conflict checks, especially in larger law firms. You know, you've got a multinational firm with thousands of attorneys working, and they've got hundreds of thousands of clients. They won't take on a new client without running a fairly thorough conflict check to make sure that those problems don't arise. And that's by like checking their entire database of who is this person connected to anyone that we've ever represented before. Now, sometimes that can be easily handled. Doesn't mean you can't represent that person by getting what's called a conflicts waiver. Let's say you represented this person's cousin for a DUI 10 years ago, and now you're charged with something, and you might need to get a fairly straightforward conflicts waiver so that you can't ever claim there was an issue later on. Sometimes too, you can represent two defendants. This is also where it becomes an issue. If there's co-defendants, usually each person needs their own attorney. Well, you can have a conflicts waiver signed by those two people so that you can represent both people. And I've done that before too. But usually if it's going to head to trial, everybody needs their own independent lawyer, because you never know how things are going to go. Who's going to point the finger at who? People who might seem to have very lined up and similar objectives might have to turn against each other when it really the tough gets going. And so you need to get a conflicts waiver from those people. I've had situations where I have had to get conflict counsel. So I've had to conflict out of representing one client because I'm going to represent another client. You know, I'm going to keep the first person who hired me, but the second person, I have to get another attorney for them. That's quite common. And as far as like late discovery of conflicts, I was trying to think of a situation that I was aware of. It does not happen all that often. In Sky's case, I think it happened with a kind of an issue that arose late, not like a personal, not like a relationship they discovered, but it was an issue that arose. That's me trying to read between the lines. And I'm sorry I'm being so vague about it, but that was kind of the impression I got in speaking with her. Alan Jackson actually had a case where he had prosecuted a person during his time as a prosecutor. And then later, when he was a defense attorney, he was hired by a person that had a relationship with that defendant. And when I say relationship, I don't mean romantic. I mean kind of a business relationship. And Alan felt that the crime that he was representing this new person for was unrelated enough to that other person that he could represent him. Well, the prosecution felt very differently about it and brought it up in court. End of the day, Allen ended up having to conflict off of that case. His argument was, we're dealing with, you know, I prosecuted that guy for apples and now I'm defending this guy for oranges. But the court felt, nah, it was a little too close. They both are merchants out of the same fruit cart. So we're not going to let you handle that one, Allen. So he had to move on from that. So it does happen. Great question, though. My dude, Court Dog Daniel from New Britain, Connecticut. All right. Oh boy. Here we go. It's the final three, everybody. Try to keep it together. Try to maintain your composure. Here we go.
Hey, Josh, Courtroom Confidential, members in chat, Tiffany, mods, and of course, my confidential Grizzlies. This is Court Lurker calling from Spokane, Washington. I've recorded this multiple times, so I'm going to try and hurry because I've missed the time every time. So, my question, Utah versus Meggan Sundwall. The jury was summoned for amount of time. The state has brought it up to the judge. They don't think they can get their evidence in and their case done by the amount of time allotted to the jurors. The judge has been very adamant the jurors will get the case this time, not at this time, and so forth. So the state has cut out a lot of evidence. My question is, doesn't that hurt the case? Like, what happens when it goes above and beyond what the jury has been summoned for? Is that appeal central? I mean, what happens to all the evidence that the state has cut out? What if that is a not guilty verdict and that evidence that was cut out would get that guilty verdict or vice versa? So I'm just kind of curious what happens in that circumstance. I thank you so much, and I hope that makes sense because I did cut out a lot. Happy Sunday fun day, everyone, and see you in chat.
Court Lurker, love that name, from Spokane, Washington. Let's put you on the mat. It absolutely made sense, your question, and it's a great question. Talking about the Meggan Sundwall case. This case is wild. It's going on right now. She's accused of murdering her own friend by overdosing her on insulin, and the friend said she was dying from cancer and she wasn't dying from cancer. And the prosecution says that it was all to get life insurance. And turns out she never even had life insurance. It's just a wild set of circumstances. But Court Lurker's question, though, is about the jurors and the judge moving this case along quickly. First of all, one of my pet peeves that I cannot stand is when judges, I am fine with judges who want to run a tight ship and want to keep things moving along quickly. I appreciate that, actually. But when judges put these artificial deadlines on things and tell lawyers that they need to get things done quickly, it drives me up the wall. And I'll guarantee you, it never fails that the judges who are so breathing down the necks of the lawyers about move this along, you're going to have to, sorry, counsel, but you've got to, you've got to finish this witness in the next 15 minutes, are the most long-winded judges of all time. They're always the ones that suck up all the air in the room with their own bloviating and then move the attorneys along so quickly. And they're the ones doing the actual work. But I digress. The answer to the question is, well, one, just because you're summoned and told that the trial is going to take a certain amount of time doesn't mean that by that time that clock is up, you just walk. That's not how this works. Trials sometimes go long. We try our best to estimate time. In fact, most times they will err on the side of overestimating the amount of trial so that jurors are not upset, so that they can plan their lives. Two, to somebody's earlier question, that's why we have alternates. If you have told a juror that you'll be done by March 22nd, and they've got travel plans on March 23rd, you let them go on their travel plans because you throw in an alternate to take their place. But to your question about, does it create appellate issues? For the prosecution, probably not so much. The prosecution can pound their fists and yell at the judge and complain and everything else. And the judge will just say, keep it moving. My question to you is, what about the defense? What if the defense wants to put on a case? What if they have other witnesses? What if if you're not allowing them to do that, you could be trampling over their due process rights. And that could be creating some real serious appellate issues. Prosecution, not so much. Prosecution can't really appeal. They can complain. They can try to, writ the judge, whatever. But if you start cutting short the ability to call witnesses or thoroughly put on a defense by the defense, you got a real problem there. And that judge should be concerned with that. So thank you so much, Court Lurker, for asking the question and for getting me all worked up this morning. Yeah, just bothers me. Like, these judges, they put on a black robe and all of a sudden they become, all powerful. All right. Let's keep it rolling here. Right. I cut that part out. Sorry. Court Lurker says, I've cut that part out. So sorry. Yes. Yes, Josh. Okay, good. All right. Where are we off to next?
Hello, Josh and CC crew. This is Krista from Tellico Plains, Tennessee. I am calling about the Kouri Richins verdict, and I want to know, do you think without the walk the dog letter that they would have gotten such a quick guilty verdict? Because for me, that letter was the turning point. That's when I knew, okay, she's guilty. This woman did what they say she did. I just wanted to know your thoughts on that, because to me, the rest of the evidence kind of wasn't that strong until she basically told on herself. Thank you so much.
Krista from Tellico Plains, Tennessee. Let's put you on the map. So great to hear from you. Kouri Richins and the walk the dog letter. How important was it? Would they have come to a verdict so quickly? Would they have come to a verdict at all? I think the answer is that they would have. I think that they likely would have found her guilty with or without the walk the dog letter. I think there was a significant amount of evidence pointing towards Kouri. What is she doing calling up and saying, I want the Michael Jackson stuff? She's not saying she wants the Michael Jackson stuff because she hopes it might help her moonwalk. She's saying she wants the Michael Jackson stuff because she wants somebody to end up dead after taking it. I think there was a lot of it. Mainly the question came down to no one else on earth benefited by this man being dead but Kouri. No one else on earth really wanted this man dead but Kouri. Now, the walk the dog letter, I think, was a significant piece of evidence and perhaps arguably the strongest piece of evidence against her. And I still think the case could have stood without it. What I think the walk the dog letter did more than anything is did it hasten the verdict? Perhaps, because I think then all of the hand wringing that you have from jurors kind of went away. Jurors, in my experience, you're dealing with a couple of things. You're dealing with the burden of beyond a reasonable doubt, but you're also dealing with the burden of these people sleeping well at night. Jurors want to feel like they did the right thing, and they also want to feel like they can rest at night and not feel bad about it. And when you have a defendant essentially out of their own mouth, out of their own written word, all but admitting their involvement in a crime, that's going to make you sleep easy at night. That's going to make it not so difficult. That's going to take out the hand wringing and the consternation and the back and forth. And are we really doing the right thing? That probably more than anything sealed the deal for the jurors. And I think they've said as much, the ones who have talked about it. But great question. I think the case did not entirely depend on it, but it certainly was very, very helpful. And Tiffany points out that Nate Eaton did an interview with juror number 3, that if you guys want to check it out, it's very interesting. Please send him a little love from us. All right, everybody, here we go. Joy W. Can, thank you so much for supporting the mods with coffees. Appreciate you. Gossip Rumor is 1,000% juiced. Look at that. See, she got it. She went off the scales, everybody. And Angela Turtle Mom has been a member for 7 months, everybody. She says, thank you, Josh, Tiff, and all of the CC crew for all you do. Well, we appreciate you for being here. Who is bringing us home today?
Hi, Josh. This is Taiwanda from Huntsville, Alabama, calling for the first time, but I've been a long-term watcher and lurker. I am calling about the Hawaii attempted murder case with the anesthesiologist who's claiming self-defense. I'm calling with a question on, can a defense attorney win a self-defense case in this type of case with these circumstances without the defendant taking a stand? Usually self-defense cases that I have seen, the defendant has had to take the stand. Can it be done through this case without the defendant taking a stand? Just want your opinion. Thank you.
Taiwanda, what a wonderful question to end us off with here today. Taiwanda, first of all, calling from Huntsville, Alabama, and a first-time caller. So great. Love that. And thank you so much for all your support and for listening and for finally working up the courage to call in. And it's a great question. We're talking about the Gerhardt Konig case out of Hawaii. I'm glad that we got a question on this one because the trial is currently going on. In fact, the victim who survived, by the way, his wife, Ariel, is set to testify on Tuesday. Look at them. Unfailing. People who kill each other. This is the one sign of people who married couples who somebody's going to kill the other one is they take really nice pictures together. See that? You take a nice picture together, and it's the writings on the wall. So, but you ask a question that I love because he is claiming self-defense in this case. He is claiming that his wife attacked him, and in an effort to defend himself from that woman, who, by the way, put up that wedding photo again, please, Kaylin. You could see how intimidated he would be by her, right? That she meant him harm, and the only way he could defend himself from that monster of a woman was to beat her over the head with a rock more than 10 times. They have 2 kids together, by the way. Okay. The prosecution's theory is that he found out, or at least suspected, that she was cheating, and so he was going to bring her up to this beautiful hike. I just love that too. How do you work that? How do you put that conversation together? Hey, honey, would you like to go for a hike? That's another one. Be suspicious, ladies, of hikes. Take you up for a hike, and then he was going to inject her with something. I think what he was going to do was inject her. He had brought hypodermic needles with him. I think he was going to inject her with something, hoping that knocked her out, and then push her off the cliff and say she fell. That was my suspicion. By the way, brilliant doctor to not realize that an autopsy likely would have shown something in her system, but neither here nor there. He is now claiming self-defense. And to Tawanda's point, is this one of those cases where he's going to have to testify? And I've actually said this. I think the rare circumstance where a client or where a defendant needing to testify is in self-defense cases, because uniquely in those cases, the jurors need to hear information that probably can come from no other source but the defendant. So much of a self-defense case is about what was going through the defendant's mind. We talk about surrounding circumstances, the totality of the circumstances. It has to do with what did that man in that moment perceive, feel that he needed to respond with deadly force, feel that he needed to use that amount of deadly force, and all of it being reasonable. And who can do that? But who is better to do that but the defendant? And so I think this is a situation where he's going to need to testify. Could they get through this without him testifying? They could. I don't think they have much of a chance. Then all you're left with is some eyewitnesses who I don't know if they actually saw it happen or heard it happening. Her testimony, by the way, she didn't die, so she's going to testify as to what happened. If he doesn't testify, there's no there's very little argument that the defense can make. I think after she testifies, he's going to have to testify and say, she's lying. She attacked me. If he's got any chance at even one of those jurors having some questions, he's going to have to testify. Great question, Tawanda. And thank you so much for being a first-time caller and being part of the conversation. Appreciate you. All right, you guys, don't go anywhere. I'm watching you through the computer. I can see you. Don't hit those buttons. Don't get anywhere. I got some quick announcements for you, and then I'll let you out of here. First, let me tell you about a website called thecourtroomconfidential.com. On thecourtroomconfidential.com, you'll find 3 very important things that I call the 3 M's. If you liked the questions here today, but we didn't answer a question that you have in your head, well, then you can go to thecourtroomconfidential.com and click on leave us a message, and that's how you can leave us a message that we will answer for next week. Tiffany reminds us we have new show times too, so we need you stick around for those announcements. So the first M is messages. If you want to leave us a message for next week, go to thecourtroomconfidential.com. Membership is the next M. If you were not one of the folks who received all of the incredibly kind and generous donated memberships today, and you want to join up, then go to thecourtroomconfidential.com and click on become a member and find out about all the benefits of membership. So Emma Lee Neely just did that, everybody. So be like Emma Lee and join up at thecourtroomconfidential.com. Navy Nurse 406 just became a member. See how easy that is? Be like Navy Nurse. GA Cat Mom, I'm guessing that's Georgia Cat Mom, just became a YouTube member. Be like Georgia Cat Mom. Megan Ross just became a member. Be like Megan Ross, everybody. Look at great examples everybody's setting here because they went to thecourtroomconfidential.com and clicked on become a member. And then finally, merch. If you like this shirt that I'm wearing here today, or if you like any of the other colors, or if you're thinking to yourself, I need a new mug, I need a new tumbler, I need a new hat, I need a new zip-up hoodie, I need a new sweatshirt, I need a new quarter zip, I need new pajama pants. Whatever it is that you might need, we've got you covered at the shop at thecourtroomconfidential.com. Please check it out. Lots of cool stuff coming your way that we hope you all enjoy. Also, what did you miss this week? Well, on Friday, we have 2 things for you. First of all, we had the weekly roundup here on our channel, or pardon me, we'll go to the weekly. Don't do this to me, Kaylin. We were doing so good. Now you got me jumping all over the map. We'll do the weekly rap sheet first. The weekly rap sheet on FoxNation.com, on Fox Nation, it's a streaming service, is a show that I co-host along with Paul Morrow and Donna Rotuno. Our latest episode just came out. Please check it out. We talked about Kouri Richins, Ashlee Buzzard, Darren Lee, and the AI cases. Really fascinating conversation about that. So please check that out at Fox Nation. And then on our channel, we had the weekly roundup, which we have changed the format. And it seems like it was a resounding approval from all of you. So instead of it being kind of a little scripted and a little pre-planned, we just said, to heck with all that. We threw the script out the window, and it's just a bunch of live rambling nonsense from yours truly, but we're still wrapping up all the important cases from the week. We talked about Kouri Richins and Gerhardt Konig and Aaron Spencer and much, much more. So please check that out. It's up on the channel now. Would love to get your feedback. And Becky B says she's loving the new format. There you go. Nobody seems to be upset with it. So thank you for that. Then coming up this week on Monday, new time, everybody. We are, instead of going live at 5 p.m. Pacific, we're going live a couple hours earlier at 3 p.m. Pacific, 5 p.m. Eastern. And there's a reason for that, because we have a very special guest for you who is on a different time zone, and we didn't want to keep her up to the wee hours of the morning. Gisela K from Grizzly True Crime is going to be joining us to talk about, what is this guy's name again? He is the Idol, the former American Idol contestant who has now been accused of murdering his wife. He says it was a horrible breaking gone bad, everybody. Caleb Flynn. And the police said, yeah, not so much, Caleb. Sing that song to another person. Get it? Nobody gets it. Nobody likes that joke. Anyhow, Gisela will be on, bringing all her snark and all the Grizzly crew with her So please check that out. Like I said, 3 p.m. Don't miss it. 3 p.m. Pacific, 5 p.m. Eastern, a little bit earlier so that she's not staying up till the middle of the night. Then finally, Tuesday, here's why you should join the Courtroom Confidential membership crew, because the hottest new show, or hottest new event, I should say, this is a special event, right? This is a tea party with Tiffany and Kaylin taking place this Tuesday. It's a Zoom hangout for everybody who's in the top secret and above membership level. It will be live at 1 p.m. Pacific, 4 p.m. Eastern this Tuesday. Whoop, whoop, tea party Zoom, you all. The Zoom link will be in the membership tab. So if you are in the top secret or above membership, you're going to have a tea party with Kaylin and Tiffany. And I don't even think I'm going to be there, right? Am I going to show up? Are you going to allow me? No, I'm not allowed. She said, maybe I'm allowed if I behave myself. If I sit quietly in the corner, she says, maybe I can show up. It's going to be fun. You guys shouldn't miss it. That's Tuesday. Then Wednesday, still working on a guest, but we will be live at 5 p.m. Pacific, 8 p.m. Eastern. And then we got a new time for Sunday. Why are we doing that? I forget. But we're moving our Sunday Fun Day to a different time on Sunday. And we're just giving you a heads up. I know it's a week out, but it will be at noon Pacific, 3 p.m. Eastern on that Sunday. All right. Other than that, other than having your whole, family stuff that morning. Okay. Other than having your whole week covered. By the way, I missed Friday. Friday's still going to be weekly roundup. I've even got your May covered, because in May is CrimeCon from May 29th through 31st in Vegas. And there's 2 reasons why you should show up. Well, there's a bunch of reasons. 1, we're going to be there. 2, it's a blast. 3, you can get 10% off if you enter the room, courtroom, all in caps, all one word, when you buy a ticket at checkout. And we have an exclusive shirt, everybody. We co-branded with CrimeCon for this brand new shirt. It says, let's keep it rolling on the back. You get it? It's about rolling dice and then about moving it along. Anyhow, we're very proud of this shirt. It arrived, our shirts arrived the other day, and I love it. I'm very proud of it. So please get the shirt and wear it to CrimeCon. Would love to see a whole ocean of us wearing that shirt. And we're going to make it available to everybody who's in our membership starting April 1st so that you can have it ahead of time. So we would love to see you all there. All right. That's all I got for you. Court Lurker, thank you so much for the super sticker. You're fantastic. Eroy says, airport approved PJ pants. Yes, they are. Even in the Tampa airport, you can wear those PJ pants. We've checked, and there's been a final ruling on that. Very big shout out and thank you to Eric Faddis for being our phone a friend. Special shout out and thank you to Afton, Sonia, Kathy, and Therapist for being the best mods on YouTube. And Debbie again. Yeah, thank you for putting that up one more time. Debbie, that was incredible. Whenever you watch this, Debbie, I hope you had a wonderful day with your family on Sunday, but I hope that you catch up on this, and I hope you know how much we appreciate you and how much love we're sending you. Special thank you to you, and special thank you to Kaylin. Everything you do is incredible, and you amaze me every single time. And to Tiffany, you are, as always, the best thing that ever happened to me. Have a great day, everybody. We'll see you all tomorrow. Take care.